The parties are represented here today. The plaintiff, it's the party Josemans, it's Madam Carlson and Mr. Bogdanovic. And the Major of Maastricht is here represented by the lawyers Mr. Kirst and Mr. Tuck. Morning. We're also here represented by the legal services of the European institutions, the European Commission, the Council and the Parliament. And we are also here represented by the representatives of the member states, the Netherlands, of course, involved, Belgium, Germany, Republic of Austria, Republic of Poland, and the Kingdom of Spain.
The Maastricht regulation prohibiting non-residents' access to the coffee shops, if that falls within the scope of the EC Treaty, namely as regards the specific provisions regarding free movement. And it is our submission that Article 49 does apply in this situation. We are aware of the fact that there are some preconditions that needs to be fulfilled in order for us to be able to apply Article 49. And the first precondition that needs to be fulfilled is this cross-border element. But since the beneficiaries of Article 49 are not only the provider of the service, but also the receiver of the service, then this cross-border element is present in our case. Then there is the entire discussion about the sale of drugs, whether that falls within the scope of Article 49. And the mayor of Maastricht has, in that context, been bringing up the case of Happy Family to support that the sale of drugs should be falling outside the scope of Article 49. However, we will demonstrate that the circumstances in the Happy Family case were very different from the circumstances that we are dealing with today.
The aims able to be used are the reasons for implementation of the principle of proportionality stated in the Article 46 of the EC Treaty. The mayor himself agreed that the usage of public security as a reason for justified violation of the Article 49 is far from being possible. That's why the other reasons, protection of public policy. The main reasoning for that particular issue is that Maastricht does have no resources for fighting the nuisance otherwise than violating Article 49.
First, I would like to draw your attentions, or basically that we're following Mr. Joseman, that the provisions of free movements of goods are not applicable. There are no facts allowing the establishment of a cross-border element. Secondly, the provisions of free movement of services do not apply either. As far as first we have to make a distinction between soft drugs and other legal products sold. Under soft drugs, we actually argue that there is a clear doctrine in Happy Family, and therefore soft drugs do not fall under the provisions of the EC Treaty. And it seems as the plaintiff has misunderstood the Siberia coffee shop case.
First of all, I would like to point out that the Articles 12 and 18 are not applicable on behalf of the soft drugs, since the EC Treaty as a whole is not applicable. The soft drugs, they fall outside the scope of the community law, and therefore no such discrimination can occur. This is confirmed in the Martinez-Sala case, out of which a contrario can be deducted that there is a need for a specific ground in community law. The distinction is proportionate. Other less interfering measures have proven, and I must stress that they have proven to be insufficiently effective. Drug tourism and the related problems are not a new thing, and tons of other strategies, as adopted by plenty of other border municipalities, have proven to be insufficient. A total ban would be disproportionate, but this ordinance is definitely proportionate.
It is the position of the European Parliament that Article 2 of the Maastricht Business Ordinance violates the EC Treaty, and therefore it should be struck down on the basis of incompatibility with this treaty.
We do contest the suitability of the measure, saying that this measure is not going to stop the flow of mass of mass drug tourism, but only going to deviate it.
In principle, we can only accept the free movement of services and the provisions of free movement of services, but they're still justified under any provision, public policy and public health. We're not going for public security as the other party wanted us to, and so under public policy and public health, I'm pretty sure the court will follow us.
Well, I think it's a very important case we have today, especially since the only case law we have on this issue goes back to 1988, as already stated, is 22 years ago. So it's a milestone that needs to be set today, and we think that in the light of the development that has been in the European community, the court will have to decide otherwise today than it did in Happy Family.
We've been very surprised that people's personal opinions and their legal, the opinions that they're representing here are actually a lot of the times very similar.
The consequences of the case is something I've actually given some consideration to, and I feel that the consequences could be particularly wide-ranging for Dutch drugs policy. Depending on the decision, it could very well lead to a situation whereby the Dutch are forced to abandon their gedugbeleid and actually force the closure of all coffee shops and become a state in line with the drugs policy of many other European states.
And I'm sure the court's judgment, as well as, of course, the conclusions of the Advocate General, will be excellent. And we will send that to the Court of Justice too, of course. Thank you very much. It was great. I'm very pleased. And good luck now to the court and to the Advocates General to find good conclusions and a sound, reasonable judgment. Thank you very much indeed.